Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. For today's episode, episode 138, we're going to continue our discussion on electronic wills, which is a new trend. And for this part 2, we're going to dive into the simple question of who and where, and we're going to discover that it's not as simple of a question as you may anticipate it to be at first glance. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, the caveat out of the way, as I mentioned last time, Colorado has recently adopted the Uniform Electronic Wills Act, and it's joined a handful of states that have either adopted that act or their own version of electronic will laws. So, the big question before we dive into more specifics is whether this could create a cottage industry or really aid the expansion of virtual estate planning practices, which is very important in a post-COVID world because you can't always meet with clients in person, and traditionally signing estate planning documents was an act that had to happen in person, whether it be at your office as an attorney or whether you're directing the client to go find two witnesses that are unrelated as well as a notary on their own. What we're going to see is that this likely won't create a cottage industry, especially because you can't necessarily say, hey, this other state has electronic wills laws, I'm going to just use their laws to create an electronic will, even though I have no ties to that state whatsoever. So, while that seems to be what a client could do, there are limitations that will prevent them from doing so. What we're going to find out is that you have to have some sort of presence or tie to the state in which you execute an electronic will. So, the dream is that estate planning becomes completely independent of location. And we've kind of gone that way with some things like beneficiary designations. Now, as you may know, beneficiary designations, if you name an individual as a beneficiary, will completely override and supersede your estate planning documents, for better or for worse. And not only that, beneficiary designations can simply be created or changed through an online form, mainly because they're not really testamentary instruments, even though they have testamentary effect. Instead, beneficiary designations are just contracts between a financial institution and an account holder directing where an asset or a life insurance proceeds or something like that is going to go. And even in some cases, I've heard of institutions allowing oral instructions to change beneficiaries, which can create huge issues as well, mainly because there is no anti-fraud protection for beneficiary designations. Now, a lot of people misconstrue electronic wills to give that same flexibility. That's why this is so exciting at first glance. It makes you think that, hey, estate planning is no longer location dependent, attorney dependent, or even attorney visit dependent, because we live in a time of increased scarcity of time, and people just don't have the time to travel to an attorney's office and get this done. So the hope and the dream with electronic wills is that whether it was justified that this could create that flexibility for clients and for practitioners, but it doesn't, mainly because electronic wills are still subject to the same formalities as paper wills. The only changes are that in some cases the physical presence requirement for witnesses has been relaxed. Now, sometimes witnesses still have to be in person. It's just the difference is they're now watching a testator sign a will on a screen instead of signing it on paper. And that may also apply to the notary as well. The notary may not have to be physically present in the same place as the testator anymore, but the state would have to change its notary laws to allow for remote notarization as well, which is completely separate and independent from electronic wills. And signature requirements may be relaxed a bit for electronic wills. Under the uniform law they have been, but not in Colorado. We'll examine that issue in another episode, where maybe you can have a typewritten signature or mark instead of having to have a handwritten signature. Those are really the only changes under the electronic will when compared to more traditional paper wills. So that doesn't create a lot of flexibility here. So most wills traditionally have been tied to a state, mainly because wherever you live, you pick that state's laws to govern your will. And will formalities are ultimately a creature of state law. And the formalities are pretty universal state to state. And there's some differences, but generally, a will that's executed in another state when you live there or when you're present there is given application and is respected in all 50 states in most cases. So for example, if you wanted to create a paper will in Colorado, you'd have to either live in Colorado or be located in Colorado at the time of execution. So in other words, you had to claim residency or domicile or just be here to avail yourself of Colorado's will statutes. Now, we have an increasingly mobile population. Residency is a loose concept, and domicile is a loose concept, and I feel like it's going to continue to be even more so post-COVID, that you're no longer really going to have a place where you live most of the year, that you could nomad yourself around, working in different places, especially with remote work arrangements. So the big question is, with electronic wills, does that mean you can just pick a state that allows electronic wills, even if maybe you just visit there briefly and then execute a new electronic will there and have it take effect in the state in which you live at the time of your death? The answer is that probably not, because there's some caveats. For example, with Colorado's law, unless you're located in Colorado when you sign it, or whether you're in a state that recognizes electronic wills at the time of your death, which is a very short list, then you're not going to be able to just execute a will in, let's say, Colorado, an electronic will, and have it take effect where you live. You can't just go to another state and have an electronic will done with no ties to that state whatsoever. However, if you later moved to Colorado and then died there, or if your state adopted Electronic Will Act, then the electronic will would be valid. So overall, this prevents some forum shopping for electronic wills, at least in its infancy here. And it's important to note, too, that you could have an electronic will in another state that's effective as to real property in that state, but in such a case, it's probably a good idea to avoid ancillary probate anyway, so that planning issue is kind of moot. So, long story short, I just want to leave you with this simple conclusion that to execute an electronic will, you have to follow the traditional will formalities with some relaxation, which we'll expand on in a later episode. And two, there's some ties to the state in which you're executing the electronic will. So you have to either live in that state that recognizes electronic wills at the time of the execution or at the time of your death, or be located in a state that allows electronic wills at the time of execution, or if none of those apply, you have to just hope that maybe your home state later adopts an Electronic Wills Act prior to your death. Otherwise, if those requirements aren't met, you're not going to have a valid will. So, while we hoped in a grand scheme to have a more virtual type of practice approach where we could get rid of physical presence and physical meetings, those still might continue to be paramount, or at least required in some capacity in representing a client for estate planning. And even if electronic wills become universal among other states, a complete estate plan contains a number of other documents which may not be executed electronically, at least not universally. Those include things like trust, durable powers of attorney, living wills, tangible personal property memoranda, which could be incorporated by reference into the will, and deeds. So ultimately, at best, what an electronic will does is it's convenient, but it creates an incomplete estate plan. And at worst, if you have no ties to the state in which you create an electronic will, your will might have no effect. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.